Mr. Whitlock, can you hear us?
Yes, I am. Can you hear me okay?
Yes, we can. Perfect. Thank you.
Thank you.
some stuff to work.
Sorry, folks, we're just waiting for one more commissioner so we have quorum. So we do recognize that we're past our time, but we just want to try and get a quorum so we can get the business done today. Yeah, so procedurally what we'll do is we'll call the
All right, we're going to call the meeting to order. Can we get a roll call, please?
Yes, Mr. Bender, Mr. Camiller, Ms. Powell, Mr. Thomas,
Yes? Or here, sorry.
Mr. Whitlock,
Present virtually.
Mr. Wing.
Here.
We have 3 present.
And because we don't have a quorum, we're going to be taking things out of order. Another commissioner is on the way, so we will be able to vote on the action items today, but we're going to do staff reports and other things that don't require a quorum first while we're waiting for her to arrive.
Okay, I'll let you take it away, Kelly. 'cause I'm pretty sure-
Thank you, Mr. Chair. Good afternoon, Commissioners. I am Kelly Aiken with your Planning Department. I have a really super brief report for you today. So just to let you know, we, if we can gain a quorum, we don't have any business for your next meeting, which is, we do have business for your September 4th meeting, but not for the September 18th meeting. So we'll see you back here in 2 weeks. Wanted to give kind of a brief update on what's happening with House Bill 4037 and Senate Bill 974. So we've been working pretty diligently on what needs to happen with the code, updating our code to align with the statute. It's a huge undertaking, and there are still some question marks about how exactly it is that we're going to process our land use applications. Right now, anything that's residential has become a type 2, which is a director's decision. So still with notice, so there's still the opportunity for the public to participate, but it's quite limited. And then the public won't have any opportunity to appeal any of those residential land use decisions. So that's what's happening. More to come on that. I don't think I have any other updates for you unless you have questions for me.
Since we have the time, we're waiting. I have a question about.
Sure.
When we go through and we change our own code and ordinances, we still are facing that shall language or versus the may language.
Mm-hmm.
So do we have discretion to kind of go down a certain path and then be slapped back if we go down the wrong path or not?
I don't believe so. I don't think that there's any discretion. I think we're reading the may as shall. Yes.
Okay, but the bill does say may, right?
What it says is may only, and you've got to read the may and the only together. The legislature could always make things easier than it does in terms of grammatical construction, but may only is the legal equivalent of shall.
Okay, that works.
Thank you. All right. That's all that I had. Just had another text from Commissioner Powell. She says she's coming out of Central Point, so she's on her way. So that's all that I had for you, unless you have other questions for me.
I don't, thank you.
Thanks.
And then I guess messages, papers from the chair, I don't have any, because I'm normally not the chair. Is there any remarks from any of the commissioners?
I did have a question. I heard Eric in the previous discussion about the legislative changes, and I'm curious as to whether we have heard anything at all from the Ethics Commission on the question of the commission's responsibility relative to meetings. I know you sent off a letter, boy, months ago at this point. Have we heard anything at all from the Ethics Commission?
Great question, Rick. No, the Ethics Commission never responded to that letter. I will maintain that it is my office's position that commissioners are responsible for acts that they're personally involved in. If you take a gift you're not supposed to take, or you engage in improper communications that you're not supposed to do outside a meeting, that's a you problem. In my perspective, if a staff member messes up notice for a meeting, that is not a problem of the commissioners. I can tell you, everyone here, League of Oregon Cities has been actively engaged on this issue. We did have a bill that would have fixed some of our concerns that ultimately was vetoed by the governor last legislative session. There is a legislative work group ongoing right now that I am a participant on to take a second bite at this, try and avoid issues that may have caused gubernatorial veto, and try and fix some of these issues through the legislature, because right now we are not hearing anything responsive from OGEC itself. So energy is still being spent on this. My legal opinion has not changed, but no, we've not received affirmative confirmation from OGEC that they are walking back that statement. Now, I will say, as I've said, typically when it comes to annual trainings for commissioners, there is a great training that meets all the requirements for commissioners that's on YouTube. It's from Barry Elsner Hammond, free of charge. I do really endorse their training. The attorneys at Barry Elsner are great at what they do. I think that's a great training. Without getting too much into details in a public meeting, I've not always seen eye to eye with OGEC itself in terms of how the administrative rules and statutes are read.
Thanks, Eric. Do we have an annual requirement to have that training, or is it one time when we join the commission, and obviously one time when they put that mandatory training into the statute?
I
Is it
believe
annual?
it was one time per term. Is that right, Kelly? Yes, one time per term. So if you're, I can't remember if this commission is a 2-year or a 4-year term, but one time per term. In case
Got it.
people can't tell, I am in full filibuster mode right now.
Fair enough. Hey, Eric, one other question, and that is, I understood the governor's concern about that legislative veto you were talking about had to do with the serial meetings provisions and not anything related to this liability issue. Is that correct?
That is correct. The serial meetings issue is really what tipped that. There were some, I disagree with how some of the lobbying for journalists had portrayed the intent and the effect of that language, but recognizing that it became a hurdle regardless, we're taking a fresh look at that to try and address what we feel needs to be addressed without running into that same political snafu. So we should hopefully, fingers crossed, be able to get something a little bit more focused past next time that will clear things up for public entities.
Thanks, Eric. Appreciate the updates.
So is there any additional things on the agenda we can do or not?
I was just going to say, I think one of the items on the agenda is remarks from city attorney, and as long as we got a couple minutes to burn, I can always have remarks. So this was just as an update to folks. This was a planning commission action, not a site plan and architectural action, but it's still interesting in terms of just an update. On September 1st and 2nd, there will be a trial over at the circuit court. This is related to the mountaintop development, an amendment to the Vista Point PUD, changing townhomes to apartment buildings. As long as it's been covered in the media, I just thought I'd provide an update to folks. So What's going forward on September 1st and 2nd is basically it'll be tried to a circuit court judge, but it is the functional equivalent of a city council appeal. And so Judge Rowan will be hearing arguments as to whether or not those apartment buildings meet the compatibility criterion of amending a PUD. Which is always a fun legal battle because compatibility is one of those, you know it when you see it, very squishy terms that can be argued either way, and attorneys love that. Everyone else gets annoyed when that's how it works. But that is one of those issues. Of course, the most interesting thing about this is Kelly mentioned House Bill 4037. If this entire thing had been filed a year later, none of this would have happened because the legislature, in its infinite wisdom, took away the rights of neighboring property owners to appeal land use approval on a housing development. So this is an interesting legal battle with some both interesting procedural issues and the substantive issue of compatibility. But at least on these facts, it would not happen again if it was filed because of House Bill 4037, yes.
So, Eric, is the city attorney's office actively engaged in the legal processing of this, or have you left it up to the applicant and applicant's counsel?
So I am actively engaged, though the main litigation is going to be it's a three-way proceeding over at the circuit court, so that'll be fun. So Greg Hathaway is representing the intervener who's opposing it. Mark Bartholomew is representing the developer. I'm representing the city. The primary fight is between those two. We're representing what was the staff position and what was the Planning Commission's majority decision. We're also there to clarify how our code works. But the biggest fight is between the two other parties, and I wouldn't say we're a referee, that's Judge Rowan's job, but we are kind of in the middle of the crossfire instead of actively engaging in the crossfire. So it'll be interesting. It's a unique procedural posture to resolve something like that.
Yeah, Eric, it sounds like the city attorney's office is engaged basically in defending the city's process and procedures and rules, and not so much the factual determinations.
Yes and no. We do need to take a position on whether or not the development met compatibility. And the position that the city's taken and will continue to take is that in the city's perspective, the development is compatible as we read that. However, we also recognize that that's a subjective issue that good lawyers can argue either way. And so we also assert that there is a factual and legal basis for intervener's position, which is a prerequisite to the court having a full hearing on the issue. So we are walking a narrow line, but that's just fine.
Thank you, Eric. This is your legal field sobriety test, then?
100%. So I don't know how we'll legally check horizontal gaze and nystagmus, but I'm sure that's up next. As long as nobody asks me to stand on one foot and do the alphabet backwards, I don't know how people do the alphabet backwards. I can't do it when I'm sober.
Do not respond in that fashion, Eric, if you are ever stopped.
What could possibly go wrong?
Please tell me you're not speaking from experience.
I'm not speaking from experience. I have watched a lot of body cam of DUI tests, though, and I have to say, body cam is not only a useful law enforcement tool, it is sometimes pure gold. I'm still
And
filibustering.
for the
in case
record,
anyone's-
for the record, I was going to say my experience is not from the defendant side of these sorts of activities, but from the prosecution side.
I don't have any other comments, but I'm thinking hard to find something to comment on.
Well, let me see. Maybe I can ask a question of Kelly. This is kind of a procedural question related to one of the items on the agenda, but it's still, it has to do more with a policy issue than anything else. If the conditions of approval have changed by virtue of a commission motion, would we ordinarily put those conditions in the Exhibit A, which contains the imposed conditions, or just leave it condition as part of the motion?
Typically, Commissioner, typically we'll add them into the conditions of approval. That's normally what we do because that's how we usually manage the projects. And then the applicant knows also what they need to do. Did we miss one?
Yeah. That's helpful. I'm curious why the Exhibit A to our consent agenda item does not include the reference to the parking on Cheltenham.
I think because it wasn't, I don't think we added it as a condition because that was what the applicant had requested. I mean, we
That
certainly.
makes sense. That makes
Yeah.
sense. I see what you're saying. It was part of the applicant's application and therefore not necessary to include it as a condition because all of the applicant's requested things are granted unless we decide otherwise.
Correct.
Got it. Thank you.
Sure. I will talk another procedural thing if it's okay. So, one of the things that happened, and it's kind of a result of some of the statutory issues, there is on, I think it's 50.1, the continuation for the Weaver Apartments. And I could talk about this when we get to the item.
Okay, do I have to call the meeting back to order, or do we just do new roll call?
Yep.
Mr. Bender, Mr. Camiller, Ms. Powell,
Present.
Mr. Thomas,
There.
Mr. Whitlock,
Present virtually.
Mr. Wing.
Here.
We have 4 present.
Okay, so it's my first time doing this, so I'm going to do the best I can, guys. So first item it looks like we have is we do have a quorum now. So the first item is the consent agenda. Do you want me to read the consent agenda, or?
We can just ask that the commissioners have reviewed the consent item.
Okay. So has everybody reviewed the consent agenda, and is there any discussion about the item? So hearing none.
I reviewed it and no discussion from me.
Okay, so hearing none, can we get a roll call, please? Or I need a motion. I'm sorry, I need
Can
a
we
motion.
at least get that pulled up on the, instead of this blue one, can we at least get that pulled up?
Mr. Chair, I would move that the commission approve and adopt the consent calendar.
Get a second?
Second.
Okay, so we have a second. Can we get roll call?
Mr. Whitlock,
Yes.
Ms. Powell,
Yes.
Mr. Wing,
Yes.
and Mr. Thomas.
Yes.
We have 4 yeses.
So item 30 is the approval of minutes from the August 7th, 2026 meeting. Are there any any additions or corrections to be noted? Hearing none, we'll take the minutes as submitted. Item 40 is oral requests and communications from the audience. This is an opportunity for members of the audience to address the commission on matters that are not on today's agenda. If you wish to speak, please come forward to the podium, sign in, and tell us your name and your concern. Okay, I don't think we're seeing anybody that has stuff that's not on the agenda today. Item 50 is going to be public hearings. If you plan to testify, please listen carefully to the following prepared statement regarding the procedural rules that govern such a hearing. Statement will be read.
I'll read it. Sorry, the script. David normally staffs this meeting, but you're stuck with me
I
tonight.
just didn't want to call you David. So
It's no problem.
Okay.
All right, so I'm going to explain the rules that govern these hearings. Before the hearing begins, city staff will give a report. The report will list the criteria that governs the city's decision. After the staff report, the hearing will be open for other speakers. The applicant will speak first and may ask for rebuttal time. Following the applicant, any other interested person will be allowed to speak. Before the hearing is closed, anyone who needs more time to present evidence must ask for more time. If you ask, the hearing will be continued or the record will be kept open, and you'll have at least 7 days to present additional written evidence. Any testimony, argument, or evidence you give must relate to the criteria listed in the staff report or other criteria in the comprehensive plan or land use regulations that you believe apply to the decision. If you fail to raise an issue or do not give the commission sufficient information so that the commission and any party can respond, you'll not be able to appeal that issue to the Land Use Board of Appeals. If you do not raise constitutional or other issues about any proposed condition with specificity so that the commission can respond to that issue, you'll not be able to bring a court action for damages. Thank you.
Okay, so in order to proceed through today's agenda in a timely manner, except at the commission's request, applicants giving testimony will be given 10 minutes to present their application. Individuals having comments about these applications will be given 3 minutes or 5 minutes if representing a group or organization, and 5 minutes will be given to the applicant for rebuttal. So first on the agenda is 50.1. Consideration of plans for the construction of 3 apartment buildings consisting of 24 units, total on 2 parcels, totaling approximately 1.15 acres, located north of East Barnett Road and approximately 300 feet west of Crestbrook Road, together with an exception request to allow for parking to be located between the street and the proposed development. The development is within the C/S/P, the service, commercial, and professional offices, and MFR 20, multifamily residential, 15 to 20 dwelling units per gross acre, zoning district, which is 371W29DC 9700 and 9800. Applicant is Brent Weaver. Agent is Oregon Architecture. Planner is Stefan. Applicant was requesting this item to be continued to the September 4, 2026 meeting.
Mr. Chair, if I might interrupt. So this is a really interesting kind of an issue. So we renoticed that the applicant redesigned this development in a way that removed the need for the exception application. So what that does is it makes it now a type 2 application. So we have, yesterday, I think we renoticed it as a type 2. So this no longer needs to be continued to your next agenda. So we're just going to pull it off the agenda, and it's going to follow a separate path.
Okay, so it just gets pulled. We don't have to vote or
Correct.
motions, right? Okay.
Thank
Sounds
you.
Great. Awesome.
I do have a question, if I may, Mr. Chair.
Sure, absolutely.
Kelly, I'm curious. So did they amend their application or did they withdraw the original application and refile it?
So they amended the application. So they redesigned it so that it was out of the floodplain, and so that the parking was not between the building and the street, which was the need for the exception. So because of the redesign of the project, it just kicks it back down to a type 2, and so that's what we are doing.
Do you mean a type 2 under the current code as opposed to the state requirements related to residential applications?
It fits in the before it fits into the type 2 before the current legislation that we're amending our code for, Senate Bill 974. Yeah, so
That makes sense. Sorry, I was concerned that an amended application would kick in the new statutory requirement, and it sounds like this is really a reaction to our current code, prior to any state legislative or city council changes to that.
that's correct.
Thank you.
All right, thanks.
Okay, so I still think we should see if there's anybody in the audience that came to speak about it. Would you
Sure.
agree? Okay, so is there anybody in the audience that came to speak on this particular application? Okay, so if not, then let's go ahead and pull that off. And it looks like, so now we're going to go to 50.2, consideration consideration of a proposal for a development of 27,233 square foot Jackson County Dog Care Facility. Project would occur on a single 27.82 net acre parcel located in northeast Medford at the western terminus of Kingsley Drive with frontage along Grumman and Kingsley Drives. The parcel is a GLEP designated commercial CM, zoned heavy industrial IH, and lies within the airplane overlay concern. Proposal includes applications from an application for an exception request, relief from requirements, and then there's a code MLDC-10-425, street access and dedication requirements. The applicant is Jackson County, and the agent is Rogue Planning and Development Services LLC, and Amy is Amy Gunter. The planner is Keegan Benson. So can we get the staff report?
Thank you, Chair. Good afternoon, Commissioners. I'm Keegan Benson with the Planning Department, and I'll be presenting on that site plan with an exception request. So first, we'll go to the approving authority, if I can get this to work here.
Sometimes Zoom can, okay, you got it.
Alrighty. So application type, we have both a site plan, an architectural review application, and an exception. These are both type 3 quasi-judicial decisions with the site plan and architectural commission as the approving authority. Those applicable criteria are found at Medford Land Development Code 10.200 subsection 5B for the site plan and architectural review, and MLDC 10.186.
So Keegan, can I interrupt you for a second?
Absolutely.
Because again, I skipped a bunch of stuff and I probably have to go back where we have to, is there any commissioners that have a conflict of interest or ex parte contact to disclose regarding this application? Sorry about this, guys. Does anybody in the audience wish to question the commissioners as to the conflict or the conflicts of interest or ex parte contacts? Okay, I apologize. I apologize.
Oh, thank you, Commissioner. All right, so we've got the compliance review for the site plan and the exception. Those criteria, as stated in the code and in the staff report, are on the screen in full for both the site plan and the exception, as we can see here. And we'll get on to the project itself. So the project will develop one parcel, 27.82 acres. It is currently general land use plan designated as commercial and zoned as heavy industrial. The overlays, airport area of concern and airport radar, and the proposal is to construct a 27,233 square foot facility. We'll look at the surrounding site. To the north is vacant or industrial used land. To the south, also heavy industrial, or excuse me, it's actually light industrial. Vacant. It's also the county owns the parcel directly to the south as well. To the east, we've got industrial uses. If you go a little farther east, you reach Crater Lake Highway, and then to the west, we've got industrial uses and vacant county-owned land, and then the Rogue Valley Expressway. For the summary of the proposal, 27,233 square foot dog shelter, proposed to have 91 kennel or dog run spaces. We'll have a medical center, a surgery center, and then admin and support areas. As proposed right now, at 38 public parking spaces and 35 staff parking spaces. The public parking would come off of Kingsley Drive, which would be extended for this, and the staff parking would come off of Grumman. There is an exception request to defer development of Lear Way. So the image on the screen shows the planned routing of Lear Way coming up from the south there. So this exception request would defer development of that to a later time. Related projects, these will be coming before the Planning Commission next week on the 27th of August. There's a CUP requesting setback reduction. That'll be for this, and we'll look at that, but the Planning Commission is the approving authority. And then a zone change requesting to change it to heavy commercial, which would bring it in line with the GLUP, and we'll touch on that as well. All right, issues and analysis. We will look at the site plan and architectural review approval criteria items first. First, consistency with the general land use plan designation. Currently, they are not consistent. This requires a zone change, with the applicant is taking action on. So as a condition of approval, applicant shall bring the zoning into conformance, and this is satisfied with passage of ZC 26187. Again, that's being seen next week. For uses permitted in commercial and industrial zoning districts, the use is not allowed in industrial zoning. It is allowed in commercial. And so this will also be satisfied with the passage of that zone change. And then we've got to deal with airport radar overlay standards. The airport radar is quite close, and so within that overlay district, there's a restriction that says nothing can exceed 40 feet in height. None of the buildings proposed do, and the applicant's findings show that they're aware of that requirement and will maintain vegetation below the threshold. Well, that is satisfied. For the bulk standards, here we're looking at the standards for the presumed heavy commercial zoning for building height, lot coverage, setbacks. These are just the setbacks required by the zoning. The application as is meets for those. For the fencing standards, those are found in MLDC 10.732. And this will be table 2 in your staff report. Those are met as well. For the off-street parking and loading requirements, these will be tables 3 and 4 in your staff report. These are captured in MLDC 10.741 through 10.751, and as proposed, it does meet these requirements. These are, we see on the screen as the requirements for large parking lot design. Those need to be followed even if the parking is split up into 2 separate spaces. So we can see in that table, it's also in your staff report, that we meet the standards for this, or the proposal meets the standards for this. Moving on to bicycle parking standards. We have an issue here. The findings state that 50% will be covered, but that's not shown on the plan. Oh, I didn't bring up my little thing. All righty. Well, talking with the applicant, they are only required to show 10% of the vehicle parking as bicycle parking. And so they're only required to have 8 spaces. This requirement for covered bicycle parking kicks in at 10. So they're going to revise their site plan to just be what is required, and that will remove the need for covered parking. As a condition of approval, the applicant shall submit an updated site plan showing compliance with the bicycle parking standards, and these conditions of approval will be captured in Exhibit A. Moving on to site design standards for the pedestrian walkway requirements. I'll highlight that walkway here. The application as proposed, it does meet those requirements. For concealments for both trash, wall-mounted utilities, and mechanical equipment, the applicant has shown compliance with those standards as well. The commission can find that those were satisfied. For the landscaping, they provided a provisional plan. As a condition of approval, they will be required to produce a final landscape plan. As the code states, it needs to be prepared by a state of Oregon registered landscape architect or a state of Oregon licensed all-phase landscape contractor. For street frontage, as it's currently shown on their plan, they're meeting the requirements for the industrial zoning, but they'll need to meet the requirements for the commercial zoning, which are slightly different. I have those requirements shown on what's proposed. So as a condition of approval, the applicant will need to submit an updated landscape plan showing compliance with the street frontage landscape requirements for the commercial zoning districts. Now look at the special use regulations. These are covered for kennels and canine daycares that want to be developed within heavy commercial zoning. So as we'll see in that table that's also in your staff report, they meet all the requirements except for the setbacks, which I mentioned earlier. So they show, I've got an inset here, they just have a 60-foot setback. They're required by the special use regulations to have a 200-foot setback, but those regulations also state that with the application and approval of a conditional use permit, they can get relief from those standards. So as a condition of approval, prior to issuance of a permit for vertical construction, the applicant is required to be approved for a conditional use permit. This project will be seen next week by Planning Commission, the CUP 26191. That conditional use permit allows reductions of the setbacks required by the special use regulations from 200 feet to 60 feet. So now we'll look at the exception criteria and, well, the exception request. The criteria are on the screen. The applicant, again, is requesting relief from the requirement to develop Lear Way. They meet, actually, let's go back here. So the granting of the exception shall be in harmony with the general purpose and intent of the regulations for the zoning district and not be injurious to the general health or otherwise detrimental to the health, safety, and general welfare or adjacent natural resources. The applicants address that in their findings, and they meet the criteria. Will not permit the establishment of a use which is not permitted in the zoning district. This exception request doesn't affect that, so this meets. There are unique or unusual circumstances which apply to this site, which do not typically apply elsewhere in the city, and that the strict application of the standards for which an exception is requested would result in peculiar, exceptional, and undue hardship. The applicant has made their case that the current terminus of Lear Way is more than 550 feet from the proposed development, and construction of the public street would need to cross an adjacent uninvolved parcel of land, both of which are unusual circumstances that do not typically apply elsewhere. The Commission can find this meets the standard. The need for the exception is not the result of an illegal act, nor can it be established by one who purchases the land with or without knowledge of the standards. It must result from the application of this chapter and be suffered directly by the property in question, not sufficient to show that greater profit would result. As the applicant states, the need for the exception is not the result of an illegal act, nor is it established by the purchaser of the property. The need results from the application of this chapter, which requires the dedication and installation of a public street that does not connect to the existing public right-of-way with necessary improvements that may require substantial alterations to existing infrastructure. Here they're talking about the Coker Butte Irrigation Canal, which is that green line coming up from where Lear Way currently terminates. Relevant to the Commission's decision, both Public Works and Medford Water Commission included statements. Public Works allows that if the exception is approved, then the developer will be required to construct the street to major collector street standards along the full length of this parcel with a future application for development of the site. And then the Medford Water Commission states they have no objection. Based on these factors and the applicant's findings demonstrating compliance, then the Commission can find that the exception request is in compliance with the criteria and standards specified at MLDC 10.1862A through D. So for facility adequacy, we look at Public Works and Medford Water Commission. They've both submitted reports. Those reports have conditions of approval with them that are captured in Exhibit A. Other agency comments. We got a comment from the fire department. Let me access my notes here. Here we go. The fire department recommends approval with the condition that future development of the property will meet the access and water supply requirements of the Medford Municipal Code and Oregon Fire Code. Additional conditions will likely apply as the site is developed. A possible example is shown. Really, the fire department's just worried about making sure they have access. We got a comment from the Rogue Valley International Airport requesting an navigation, noise, and hazard easement and letting the applicant know they'll need to file with the FAA. And then Rogue Valley Sewer Services, they supply services to the site, and they have 2 conditions of approval, which are also captured in Exhibit A. Those conditions of approval are on the screen. I'll spare you reading them, but we can refer back to them if you have questions. So findings and conclusions. Again, we're looking at the SPAC and exception criteria. I think I skipped my conclusion, but the conclusion is that the findings, as recommended by staff, oh man, I lost my slide telling me exactly how to say it, but essentially, as the staff report states, as the findings illustrate and the additional reports show, the application complies with the code or can be made to comply with the imposition of the conditions of approval captured in Exhibit A. So the recommendation that the commission adopt the findings as recommended by staff and direct staff to prepare the final order for approval of AC 26188 and E 26192 per the staff report dated August 14th, 2026, including Exhibits A through J. Thank you. Any questions?
Okay, thank you. So does anybody on the commission have questions for staff regarding this application?
Mr. Chair, this is Commissioner Whitlock. I have a question regarding the exception request. Can you bring up that map again, please, that you had displayed?
Absolutely, Commissioner. Let me retrace my steps here.
Perfect. So is the expressway to the west of Learway just not displayed on this?
If you could see the pointer, it'd be about right where that is. It's just cut off, yes.
Got it. Thank you. I was just confirming its location. No further questions, Mr. Chair. Thank you.
Thank you. Any other questions? Okay, if we have no questions, let's open up the public hearing. And let's hear from the applicant or their agent.
Good afternoon, Commissioners. Amy Gunter, Rogue Planning and Development Services. I'm representing Jackson County. I don't really have a presentation. I am available for questions if you have any, but staff did a really good job of encapsulating the whole proposal.
Okay, do we
Mr. Chair, I just have one question, if I may. I was curious why the project was identified as a dog kennel, dog facility, rather than some sort of animal facility. I understand you will have facilities available for cats as well.
I'll try to be as concise. Ryan DeSalto from Jackson County is here as well, but it's essentially at the direction of the Board of Commissioners because they really only are a dog adoption facility. Though they have a few cats, it's not really a cat adoption facility any longer. That was a change at the direction of the Board of Directors 3 to 5 years ago. It's been years that they've sort of moved away from all the other animals. So they do have them. There is a cat room, but it is not where people come to like get cats to adopt.
Thank you. That explains it. I understood that the county's position has always been that their statutory obligation is with respect to dogs and not cats.
Exactly.
Any other questions? Okay, would you like to save time for rebuttal?
I don't think I'm going to need it. We'll
Okay.
just move along. Thank you.
Okay, so is there anybody in the audience that has come to speak on this application? Okay, seeing none, I will go ahead and close the public hearing. And can I ask for a motion, please?
Mr. Chair, I would move that the commission adopt the findings as recommended by staff and direct staff to prepare the final order for approval of AC 26-188 and E-26-192 per the staff report dated August 14, 2026, including exhibits A through J.
Second.
We got a second. Can we have any discussion on this application?
Pretty detailed.
Okay, so can we get roll call then?
Yes, Mr. Wing,
Yes.
Ms. Powell,
Yes.
Mr. Whitlock,
Yes.
and Mr. Thomas.
Yes.
We have 4 yeses.
Okay, and then I skipped stuff again. I apologize for that. So hopefully there was no questions from, or no comments from council or staff.
I
Let's
really
go
wanted
down
to
to-
grill applicant on this one, and now I've just been cut off from putting the screws in. So you lucked out this time.
Okay, so then, looks like item 60 is what we're on now, is the written communications, and we have none. Item 70 is new business, we have none. And we've already done the reports, so I guess we are adjourned. Thank you.